Well, the afternoon's just flying by. Welcome back. Hope your day's going great. We had a phenomenal opening session with Brian Graff and Preston Rutledge, and hopefully you were able to take advantage of some of the breakout sessions. Well, now that we're back here this afternoon, we have another one of our favorites, a legal panel. And what we've done here today is really put together an all-star cast of attorneys from different perspectives. And it's their job to share with us what they see going on in the industry from their own eyes. And the real advantage to that from we advisors' perspective is how we can see some of those challenges and turn it into opportunities for our clients and our practices.
Well, fantastic. I get the pleasure of introducing today's moderator. She happens to be a retirement consultant in the industry, a great one at that, for Simino Stroud Consulting. She was a former president of ASPA back in 2005 and 2006. She's an extremely active volunteer in the community, which happens to be Nolans. And she's a wonderful person to boot. So please let me introduce Sarah Simino.
Okay, welcome everybody. We've done this session before. In fact, we did it last year, and I was filling in for the great Steve Nybo, so I'm grateful that I get to come back. And I wanted to set the stage a little bit before I introduce the panelists. One of the things that we had success with last year was running this session the way I do high school debate, which I coach. In high school debate, you have a limited amount of time to speak, and you have a limited amount of time for rebuttal. And we felt that added to the interactive nature of the session last year. So this year we're going to do the same thing. We've pre-selected 4 topics we think will be of great interest to you. We're going to allow the panelists to introduce those and rebut those topics. And then we're going to ask for your input. And in fact, I'm giving you all as the audience more time to give us Q&As than they have to speak. So they're very interested in your point of view and what you have to ask these panelists. We do have mics up front here, so be sure and come to the mic and ask your question. We're interested in what you have to say about these kind of hot button issues. So I'm going to start with introductions. I'm sure most of you know the folks up here, but I want to, of course, give them their due. Fred Reish, you all know Fred. Fred and I go back probably 30 years. He was actually my lawyer when I was a TPA. And he has really made a career of, I think, making sense of this business for those of us who are TPAs, service providers, and advisors. And that's not an easy thing to do. He's currently with Drinker Biddle. His primary client base really are service providers. That's who he's working with. We then have Rebecca Kaplan. Rebecca was a benefits advisor under Phyllis Borsey at the DOL, so I'm calling her a recovering DOL employee. She is now the ERISA attorney for Angel Pension, which is a TPA, and I'm a former TPA, so I'm no longer calling them TPAs. I would like to call them retirement plan consultants, and that's what Angel Pension is, the retirement plan consulting firm. They have 3,000 plans, so they're very big, all across the spectrum of kind of our business. She is in charge of fiduciary education for plan sponsors and advisors. We then are very fortunate to have Doug from Fidelity. Doug was the Benefits Tax Counsel for the Senate Finance Committee, and what's fascinating is he worked with Brian Graff back in the days of SPIJBA, for those of you that go back into the 90s. Doug was very involved in that area of the law with Brian, so he has been kind of side by side with us in the business. He is now with Fidelity, and he is head of their thought leadership and policy development. He's got some interesting topics for us today. And then, of course, you all know Marcia Wagner. Marcia's another buddy from way back. And Marcia, like Fred, really has incredibly important things to say about our business in a very cogent way. She is the principal founder of one of the nation's largest boutique law firms, specializing in employee benefits and executive comp law. So that's our distinguished panelists, and we've kind of preset a little bit of topics so that we can really add some structure to this. And I'm going to be the timekeeper, so I'm going to make everybody mad, but my job is to make sure that we stay on track and that we really limit the speeches so that you guys can give us input. So that's kind of my job. If you hear me giving time signals, that's what I'm really here for. So we're going to start with Fred. And Fred, your issue is this whole issue of rollovers to IRAs, the FINRA guidance, FINRA and SEC examinations. I think this is probably one of the hottest topics we're dealing with today. So I'm going to turn it over to you.
Well, thank you, Sarah. I want to talk about distributions and rollovers because I think that could very well be the top issue, the hot issue for 2014 and perhaps for several years beyond that. Now, why do I think that? Well, it starts with money, the mother of most things. Last year, $358 billion rolled from 401ks into IRAs. Cirilli projects that between 2014 and 2018, 5 years, over $2.1 trillion will roll from 401ks into IRAs. Because of that, because of the amount of money moving from a defined contribution institutional world into an IRA retail world, the regulators are very concerned about whether or not it will be well treated in the process. They're concerned about conflicts of interest occurring in that process. They're concerned about higher retail prices inside IRAs, and they're concerned about the impact of that on the sustainability of lifetime income, on the revenues and the adequacy of the revenues produced for lifetime income for older Americans, for American workers. So what are they doing about that? Well, this all really started several years ago in 2005 when the Department of Labor issued an advisory opinion about so-called capturing of rollovers. At that time, most people thought that advisory opinion really only applied to fiduciary advisors. That's typically an RIA who serves as a fiduciary to a plan. And the sense was, pretty much correctly, that it didn't really impose much, if any, burden on non-fiduciary advisors to plans. That lasted for about 8 years as being the prevailing view. Then last year, FINRA came into the play, and they're now regulating broker-dealers. Over the last 6 months, 7 months, FINRA's issued 3 or 4 different pieces of guidance. Both FINRA and the SEC have said they're going to put rollover IRAs and distributions on their 2014 examination priorities. And in Regulatory Notice 13-45, FINRA laid out its position. An advisor can provide education about the distribution alternatives and the advantages and disadvantages of each as education, but not make a recommendation that the participant take a distribution. And that's okay. That's education. On the other hand, FINRA is saying the minute an advisor recommends to a participant that they take a distribution out of a 401k plan, that is inherently a recommendation that they liquidate the investments in their account, and that's a securities transaction. And as such, the investment recommendation has to be suitable. It'll be measured by the suitability standard. They then list a whole series of factors to be taken into account for suitability. We don't have the time to go into those right now, but let me talk about where I think you need to go to satisfy those kinds of factors. If you are going to go with education, fine. You need an informational piece of all of the issues, the 4 different alternatives for distributions, and the advantages and disadvantages of each. If you're going to go with recommendations, you have to go beyond that. I recommend that you have a checklist of the things that you're discussing with participants and you're getting input on as a part of the determination of a suitable recommendation. I also recommend that you have certain written disclosures. Think a little bit in terms of 408B2 type disclosures, fees, services, status. And then finally, an acknowledgement form. How the participant acknowledged that you walked them through that they took all that into account in making their decision, and nonetheless, they're going to take a distribution, roll it over, and have you help them with investing their IRA for retirement. Sarah, I'm
30
done.
seconds early. That's awesome. Fantastic. All right. Great job, Fred. How about rebuttals? So now we're doing a debate round, right? So, Rebecca, what do you think?
So I would agree with Fred in terms of what needs to be done on advisors' part to comply with all of the upcoming focus on fiduciary liability and capturing rollovers. The one thing I think has not been really addressed in these regulations or in the discussions about it is the fact that IRAs can really be beneficial in certain circumstances. When I worked at the Department of Labor as a benefits advisor, one of the most common concerns that we would get phone calls from participants was someone calling saying that they had left a company 25 years prior, and suddenly now that they're reaching retirement age, they realize they have no idea what happened to that account, whether the employer closed, it changed hands, et cetera, and now could the Department of Labor help them find those lost 401k accounts. So I think there is really a benefit to an IRA in the sense that there's so much inertia out there among plan participants that rolling it into an IRA is an active activity that they can partake in and then keep track of it a little more easily.
Awesome. Also finished early. Great. We're going to have extra time. It's a beautiful thing. Okay, Doug, give us your thoughts.
Oh, I think the advisors and the record keepers that have access to the millions of low balance participants that can't get full-scale advice, either at rollover or investing, I think our institutions provide a great service to those, especially with a fair and balanced approach to that. And we have actually, our experience has that we can make a significant difference in keeping assets in retirement solution, whether it's in plan or rolling over to an IRA and making a better decision than going out buying a Winnebago. And so I hope that the Department of Labor understands that sensitivity and the important role that we all play in this system.
Great. Marcia, thoughts?
I have many. First, the DOL has not yet promulgated its conflicted advice re-proposed regulations. But this FINRA notice is important. They say it's a reminder to registered reps of broker-dealers and broker-dealers themselves with respect to the fiduciary, broadly speaking, duty that registered reps have vis-a-vis rollovers in their platform providers as well. But in my mind, it's much more. It's effectively a call to arms whereby FINRA is saying quite clearly that this is going to be something that they will be examining. It is going to be an audit issue for FINRA. Importantly, if you really read the notice, it's almost a roadmap, a checklist of what they're going to be auditing. So you in the audience should read this, understand it, and incorporate it. What do I mean by incorporate it into best practices? For those BDs out there, use it as a training manual for your registered reps, especially with respect to conflicts of interest. For those of you who market out there, use this. Look at marketing materials for rollovers now as a compliance tool, as a way of taking that which would otherwise be sales and marketing and say, look, this is how we comply with the audit standards, effectively, of FINRA. It's a new way of looking at marketing. Financial advisors out there, you should have model FINRA compliant forms that you should use for rollovers that are coming from plans that you advise on and even those that don't. We've created models like this, and they deal with things such as the pros and cons for keeping money in a tax-qualified plan or not. Creditor protection. Some states, IRA creditor protection is good, some it isn't. Do you get institutional pricing? What about employer stock and NUA? Net unrealized appreciation, long-term capital gains treatment, et cetera. Those are reasons potentially to keep money in plan. Also, if you keep money in plan, you can take it out at age 55 and not 59 and a half. But then there are good reasons to have it in rollover. For example, consolidation of money. More access to different investment options, some of which might be illiquid and not available on the 401k platform. The point is, and I conclude with the thought that you need to have model disclosures and disclaimers now and use this FINRA guidance as a checklist to do so.
Terrific. Those are great points. Questions from you all? I'm sure you have them. Everybody's got all their rollover stuff in order? Ready to go? Let me ask Fred, when you talked about some of the things that you were skipping over, you said you were talking about the suitability standard. Do you want to talk about that in a little bit more detail?
Yeah, a couple of things about the suitability standard. What FINRA's saying, it's only when you're going to make a recommendation that someone take a distribution. If you're just providing education, then education wouldn't be subject to that standard. It can be general education for participants generally. It's not suitable for that individual. But what's interesting to me is if you look at the criteria, it's like bankruptcy and creditor protection, minimum required distribution, range of investment alternatives are available, the price, like are the investments in the plan cheaper, the services that are available, and a comparison. It's education just telling the participant to compare all those. To develop the suitability standard, you probably want to talk to the participant some about that. And my view of that checklist that I mentioned is you'd go through this list of things and you would say, is this real important, not important, or moderately important to you? I don't care if you adopt a 3-point or a 5-point grade scale for that, but something, because you can't deal with all those issues, so you want to end up dealing with the ones that are important to the participant to develop the suitability standard or to satisfy the suitability standard. What scares me a little bit is that you all might be thinking, I'm just talking about non-fiduciary advisors here. To me, most people believe that the prudent man rule, that the fiduciary standard is higher than the suitability standard, generally speaking. So if this is what's expected of the suitability standard and the fiduciary standard is higher, what more is expected? How many people really now, how many record keeper call centers or representatives of broker-dealers or even RIAs that are talking, fiduciaries to plans, are going through half of this now? I see this as a game changer. Even though even though FINRA said in that regulatory notice that it was a reminder, if you will, that people had to do that, nobody can find anywhere that they said it the first time so that they can remind them about it now. This is really brand new, and don't be thrown off by that use of the word reminder in the regulatory notice if you happen to look at it. But regardless of where this ends up, it seems to me that the fiduciaries are also going to bear a similar burden. If you're a fiduciary for participant accounts or a fiduciary for the plan, you're going to need to be taking into account what's in the best interest of the participant. And this effectively creates a best interest of the participant for non-fiduciary advisors as well, making securities recommendations. And if you think about it, while the fiduciary rule only applies to ERISA plans, this rule applies to 403Bs, government 457Bs, government 403Bs, ERISA 403Bs. The FINRA rule does, because that's regulating the securities transaction, not the ERISA aspects of this. This is very, very broad, and I don't think the retirement plan community fully appreciates the full consequences of it yet. But the key to keep in mind above everything else is what's in the best interest of the participant. To roll over to an IRA, to leave their money in the plan. I mentioned the 4 options. Roll over to an IRA, leave your money in the plan, transfer it to the plan of a new employer, or take a taxable distribution. I can give you examples if we had time, which we don't, but we could create examples of where each one of those in a different situation will be appropriate, will be in the best interest of the participant. That's where I see this all going.
Hey, Sarah, can I ask a question about
Sure,
that?
absolutely.
Because, I mean, Fred, you just described 3 different standards through 3 different agencies. You got FINRA, SEC, and DOL. I mean, it feels like, I'm kind of the anti-reg Christ here, it sort of feels like this is a game changer for the compliance departments. And they'll do very well in the legal team, but are we, through this whole process, are any of the participants going to gain more benefit from the cost of doing this, when what we really need is we need a consistent standard across all these agencies, whether it's a 401k or IRA or 403b or 457, because the participant will never know.
Doug, what it is?
Doug, just to answer that, the problem with the government in this regard, one problem.
Just only one problem.
Yeah, one
I
problem
think
with the government in this regard is that they're internal looking. They're focused on silo structures.
And they're kind of
agencies.
backward looking, I would say, in the past.
But they ought to be looking, I mean, what does every business have to look at? They have to look at their customer. And the customer is a plan sponsor or a participant in this context. And somehow the agencies should consolidate their thing. I don't think that'll happen. I'm not an optimist.
No, not,
but
not currently. But
it's too woven into the fabric now. But the problem is, yeah, we don't have anybody like that. You know, I do think that, I mean, to me, FINRA and SEC are harmonizing to a degree with the DOL. I think everybody was hoping it would be the other way around. The DOL would harmonize with the other agencies.
Yeah.
I actually see everybody's been out there calling for harmonization. Be careful of what you wish for,
really.
because I see it harmonizing more to the Department of Labor point of view. Having said that, 3 different standards is unacceptable. It's, I mean, regardless of whether you like one or the other, 3 is just wrong. There's too much administrative burden, too much cost.
Marcia, can you give us a quick last word, and then I'm going to move into Rebecca's topic. So give me a quick one.
Thank you. I think a metaphysical law of nature is that pendulum swing. And rollovers were the Wild West for a long time, where there was no or very little effective regulation. Now it's swinging in the other direction, where it's almost too much, with different agencies all wanting a piece of the action, a piece of the pie. What I do believe is that things eventually end up in the mushy middle where we can all live and everyone benefits, because that's in everyone's interest. You don't get there in a beautiful way. Nobody likes to see how a hot dog is made, but right now, we're in the experiment of the fiduciary hot dog.
Great. We're going to move on off this topic onto fiduciary 316 issues, unless you all ask a question. So I'm assuming, since I see no one at the mics, let's go ahead and move on to make sure we get everything in here. And Rebecca's up next, and she is going to be talking about the pros and cons of fiduciary services, primarily, and we talked about this on our calls, 316. Which, if you're a TPA or retirement plan consultant, you're probably either doing or thinking about doing. And if you're an advisor, I would guess you've got clients probably asking about it. So Rebecca, take it away.
So, you know, over the last decade or so, as plan sponsors have become more and more aware of the fiduciary liability and fiduciary responsibilities that they have toward their plans, we've seen more and more services out there, primarily in the realm of 321 and 338 services, where a plan sponsor can outsource their fiduciary responsibilities to an entity or a person who will act to monitor the investments and assist in choosing the investments on the platform. One of the things that I see commonly is that plan sponsors, when they use this type of service, they start to believe that they don't have any continued responsibility toward choosing the investments, which of course is a fallacy. They really do have the obligation to continue to monitor the service provider, and if certainly with a 321 service, they have the obligation to then make the decision as to whether or not they're actually going to take the advice of that 321 service within each individual recommendation. Now what we see is 321 services being offered by a whole variety of primarily TPAs and record keepers. This is, in other words, the service provider saying we will act as the plan sponsor, as the plan administrator to the plan and take over that fiduciary responsibility. And you could see why this would be very attractive to employers, because they are busy running their companies. They really don't have the time to be paying attention to all of the compliance issues that they need to really to look at on a regular basis. I think there's some risk in this 316 offerings that are out there now. And that is, again, as I mentioned before, a plan sponsor can never fully absolve themselves of fiduciary liability. So now if you have a plan who's outsourcing investment advice, and now they're outsourcing plan administration, there's a very real risk that they will say, you know what, I've outsourced all the responsibilities and I don't have to pay attention to the plan at all. Now, 316 services that have been offered out there thus far really vary greatly. Some of them, you know, offer to assist with participant disclosures and signing of 5500s and stop there, and others agree to take on all aspects of plan administration, including evaluating, monitoring, and selecting other service providers. So I think the first thing for plan advisors to really help their clients understand is that it's a fiduciary decision to choose the 316, and then on an ongoing basis to monitor them. So I'm a big proponent in fiduciary education, helping plan sponsors understand what their responsibilities are so that when they choose a 316 service, they know what responsibilities they've delegated and what responsibilities they will continue to have.
Great. So comments, Marcia.
Yes, I think that it's absolutely fantastic that there are vendors out there really trying to help, frankly, decimated because of this great recession, HR departments that really can't do everything correctly that a named fiduciary is supposed to do for and on behalf of the plan sponsor. It is true that there's always residual liability at the plan sponsor level, but there are a few points I'd like to make. The first is when people are buying a 316 service, not all are created equal. Certain are 316s, i.e. plan administrators within the statutory definition alone. And following on what Rebecca said, all they really are doing is making sure that reporting and disclosure requirements are satisfied. The 445, the 5500, plan documentation, SPD, et cetera. Others are using the exact same definition to go beyond, to do prototypical named fiduciary work, such as benefit claims, non-discrimination testing, tax qualification, timeliness of elective deferral, auditing, et cetera. So the plan sponsor and the financial advisor that's assisting the plan sponsor really has to help and know what they're buying, because the residual that is not being taken over by the 316 resides with the named fiduciary, i.e. the plan sponsor. Moreover, the same issues hold forth with 321s and 338s. In the 321 field, is it discretionary or not? Who has, 338 as well, because that can be truncated to a certain degree. Who has responsibility for QDIA, for IPS? Who or what is providing what level of advice or education to the plan participant? All of this comes to the concluding thought, which is quite simply that you need some type of fiduciary service agreement so it is clear as to what the 316, the 321, the 338 are, and almost more importantly, are not responsible for. So the employer knows beyond its selection and monitoring responsibilities what its residual responsibilities are.
Doug?
Well, just a very simple comment. Just the complexity of this discussion with 3 different fiduciary standards, it's just hard for me to believe that a small business that wants to do retirement plans is going to understand any of this.
Send them to me, I'll explain it.
Okay,
Yes.
so here's a question, real life, right? So some of you heard this before. My husband has a small business, 10 people. He has a 401k plan. He's married to me, so he should know more than he does, right? But he says, I lost you at 401k. What is this fiduciary crap, and why are you constantly talking to me about this? Why am I worried about that? I don't understand. I just want to say for retirement,
and,
you know, this
and I signed these 3 documents.
He
so
signs.
on.
He just signed a bunch of stuff, and he was like, "What am I signing?" I'm like, "Just do it." And he goes, "What if I wasn't married to you? How would I know what these were?" Right? I mean, he's very frustrated by that.
Right.
And we have a 338 fiduciary.
And we sign those agreements and contracts, and then he still brings the stuff home and says, Sarah, take a look at this. What did I just sign?
Well, and what he also says to me, and he gets, you know, and this is where I go back to the advisor, is he says, what's in this for me? If I'm taking on all this risk, and I'm, you know, doing this fiduciary deal, that's ultimately what they're going to want to know.
Yeah, I think it goes to the criticality is, and that's why we're all here today, is have high quality providers in everything you do around your plan.
Correct.
I mean, that's the best solution no matter what you sign.
Right, including an advisor who knows enough to be able to explain it and either provide that fiduciary education themselves or bring an outside source in to have, you know, a one-time meeting. And I know that the DOL looks favorably upon plan sponsors really partaking in some type of fiduciary education.
Fred, what do you think?
I happen to represent a lot of the TPAs who are doing this. And Let me tell you a little bit about that. But I want to start off with sort of picking up on the theme that we just talked about. I like to say nobody was born wanting to be a fiduciary. And I think that's true. You wouldn't want to be one because that says you're responsible for somebody else, and that somebody else isn't a member of your family. The closest we have in our day-to-day life to a fiduciary relationship is parent to child, husband to wife, and vice versa, children to parent. Those are what fiduciary responsibilities feel like. And you wouldn't ordinarily want that relationship and responsibility for a stranger. So why would a TPA, for example, ever want to be a fiduciary? Well, as Rebecca and Marcia said, there's fiduciary light and there's fiduciary heavy. Fiduciary light, both TPAs want to be able to market that they're a fiduciary because they know plan sponsors want to hear that the burden is being taken off of them because plan sponsors weren't born wanting to be fiduciaries either. And they feel a sense of relief just from that. So number one, first reason, they want to market as a fiduciary so they can get business from plan sponsors and outcompete other TPAs, because that's what we're doing. We're in a competitive environment.
Can I ask you a question about that? About that TPA concept, fiduciary light, fiduciary heavy? I mean, as somebody who comes from the TPA world, I'll play devil's advocate a little bit. I mean, part of the TPAs when I work with them is we want to get paid for what we're already doing anyway. Distributions, for example, elective deferrals, timing of elective deferrals. They're responsible, right, Rebecca, for a lot of that anyway. So they've got all these responsibilities that they're doing, and they're essentially not being paid for. So I think one of the motivations for 316 is, look, if we can do it as well as we're doing it now, or maybe even better, why shouldn't we take on this liability?
I will say that you're finding two role models on that. Okay. One role model is they're giving it away. They're giving away the 316. They're not charging extra for it, which I think is a mistake.
I do too.
You want to be insured for it, and you want to charge for it. Right. The market seems to be going to 10 to 15 15% differential, or basis points, 10 to 15 basis points for the pricing of 316 fiduciary services. So you have fiduciary light, and want to say they're fiduciaries. You have fiduciary heavy, or 316 light and heavy. 316 light is saying, the other thing we really want to do is we really want to take transactional burdens off the plan sponsor. Have them sign fewer things. We'll do the paperwork. We'll make them feel like we're the quarterback and we're the center and we're coordinating all this stuff. That's fiduciary light. So distributions, 5500s, stuff like that. Loans.
Notices.
Yeah, anything that takes burden off the plans, the office manager of the plan sponsor if it's a small firm. Fiduciary or 316 heavy that's legitimate, full-blown fiduciary stuff. There are a limited number of firms out there. I would typically encourage any TPA firm to really, really think about it before they go fiduciary heavy, because I can't even give you a list of all the 316 responsibilities, and I'm sure it's over 100. But even to do fiduciary light, I would like to see a firm that is certainly one that's Rebecca's firm size, maybe a little bit smaller, but very strong internal policies and procedures, because you're now a fiduciary. And the difference between a TPA doing the calculations and a TPA fiduciary is the decision making. You make decisions as a fiduciary, you just implement calculations and paperwork as a ministerial or so-called clerical TPA. So the decision making, does somebody get a distribution or not? Do they qualify for a loan or not? Is this quadro a good quadro? Is this DRO a quadro? Those are decisions that would get transferred off the plan sponsor onto the TPA. It's the decisions. Now, some TPAs come to me and say, hey, we're already doing all the work, but they're not. They don't understand that it's the decisions, it's not the work that is the fiduciary aspect of this.
And would you say to evaluate, one of the questions I get from advisors a lot is, for some reason, plan sponsors, particularly like Peter, he doesn't want to sign the 5500. He thinks like that's a big magical thing. If somebody will sign that for him, I think, to your point, he thinks he's not a fiduciary anymore. So that seems to be like a big driving force in the market is, well, if they'll sign the 5500 and there'll be a named fiduciary in the document, that means that I'm off the hook to a large extent. And I think there's a question as to what the market is saying, and then I get questions from advisors about, okay, if we're going to do this, how do I tell if somebody's a legit 316 provider or not, right? How do I know that they can really do all of this?
And I get paid a lot of money for writing fine print. I don't want to hear anybody say anything bad about it. But Read the fine print,
Okay.
because it will tell you that there are 316 for certain purposes. If that's less than 7 or 8 things, then they're a 316 light. If it just says we're the 316 broad for everything, then they're a 316 really heavy. But it's going to be a really robust list of 20 or 30 things at the least before they're taking on the full responsibility of what I would call a full-blown 316. So it's in the issues that you're identifying as taking on 316 responsibility for.
Right. The other comment I would make is that when a plan sponsor thinks that if somebody else signs the 5,500, then they're not liable anymore, that's also really putting that employer at risk, because just because you're not a named fiduciary doesn't mean you are not a functional fiduciary. So, again, outsourcing what you can to some service is still, you're still going to retain that that role of the functional fiduciary.
And that gets to some of the issues that, from the TPA perspective, one thing I draft into the agreements is, but in performing our duties, we're only responsible for the information you, the plan sponsor, give us. Like, has somebody defaulted on a loan? Did the so-called deceased participant really die such that there can be a distribution? I mean, the difference between the TPA and the plan sponsor is the plan sponsor has a big body of knowledge about the employees that has to be communicated to the TPA. Therefore, necessarily, the TPA has to rely on that. Garbage in, garbage out. They get bad information, they'll make bad decisions. And it's not the TPA's fault. But there's a lot of thought. This has to be done right, because you don't want to become a fiduciary thoughtlessly.
But I would say that, the devil's in the details on this one, and I would caution anybody who's working in this area to really look under the hood. I mean, I think that's kind of the key, right?
Absolutely.
Because we have to move on, so I'm just checking questions, all right? Panelists will be here afterwards, so if you all want to come up and ask private questions, that would be great. We wanted to not just dive into all the details of regulation, and the good news is Marcia and Doug really are policy folks, and they are really interested in some of the policy issues that we're going to be dealing with in the next few years. So I'm going to turn it over to Marcia, who's got a fascinating topic on the impact of ACA, the Affordable Care Act, sometimes known as Obamacare, on retirement plans. Marcia.
Thank you. One would think that the Affordable Care Act, the Patient Protection and Affordable Care Act, wouldn't have much of an effect on the retirement industry, because by definition it deals with healthcare. But mind you, healthcare is 1/5 of the economy. But beyond that, there will be direct and indirect, anticipated and unanticipated effects of Obamacare on employees, employers, and on the retirement community. With respect to employees, now that employees have the ability to purchase insurance through federal or state exchanges, they'll no longer be tied prior to Medicare eligibility to an employer. That is going to lead to more mobility for those that needed the health insurance. And that's going to have different impacts, particularly and especially, I believe, in manufacturing, where there at the high level is a need for these older workers to stay. Secondly, for lower paid employees, so-called non-highly compensated employees, because the individual mandate is effective in 2014 currently, you are going to find that many of these people cannot afford both to make an elective deferral in a 401k 403b and also pay for health care. Anecdotally, I can tell you, we're seeing a decrease in elective deferrals in order to supplement the ability to pay health insurance premiums, taking money out of the system and also adversely impacting non-discrimination testing and the amount highly compensated employees can electively defer, which is contingent upon what non-highly compensated employees defer. From the employer's perspective, the employer mandate is becoming effective in 2015. HR budgets in general are static or slightly increasing. If they only have a certain amount of dollars and they need to provide affordable, which I'll define momentarily, health insurance to the majority of their workforce, then you will see a shifting of monies from, for example, matches and profit-sharing contributions to supporting premium payments. Again, taking money out of the system and decreasing just when we need it to be increased the incentives to make elective deferrals. Moreover, and talk about unintended consequences. If insurance is considered to be unaffordable to employees, then in general, there's a $3,000 per employee sanction or tax, depending on your political persuasion, by the way, applicable. Now that can really add up quickly. What is affordable? If the insurance cost for the employee is not more than 9.5% of his household income, then it's considered affordable, clearly. An employer cannot administratively figure out what household income is. Therefore, the IRS very intelligently, in my mind, came up with a safe harbor, whereby if the lowest cost health insurance was no more than 9.5% of the employee's Box 1 W-2 wages, then it was de facto considered to be affordable. However, in Box 1 of the W-2 is not included 401k contributions. This is a perverse incentive, particularly in the restaurant and other low-page industries, to not have non-highly compensated employees make elective deferrals, making the insurance more affordable pursuant to this IRS safe harbor. Also, there are two great effects, I think, on the retirement industry. The first effect is that once these exchanges are truly up and running, you're going to see brokers that sell welfare benefit product having margins decimated. And where will these brokers, many of whom are quite intelligent, migrate? To the other area of ERISA, which will be pension benefit, 401k. You're going to have a lot more one-shot wonders of blind squirrels. Ironically, at the time, the government is trying to raise the fiduciary bar. And finally, if the concept of exchanges for welfare benefit product, health insurance, works, this could have a monumental effect in the retirement community, whereby the concept of retirement exchange may come to the fore. Proof? The USA Retirement Product funds that Senator Tom Harkin is proposing. So I think PPACA is going to affect our industry in ways large and small for years and years to come. Thank you.
Fascinating. It's Doug. Give us some comments on it.
So, Marcia, I agree with your point, but my research leads me to believe that this has been happening for 25 years. You just didn't know it. I mean, basically all of our benefits, your benefits, my benefits, whether it's an employer contribution, employee contribution, that's just a fiction. They're all being paid out of the individual's wages. And healthcare has been going up 4 times faster than wages over the last decade. People are spending twice as much on healthcare, and they have for years, than in retirement. So the insidious effect of healthcare is like inflation. It's just eating away of our retirement security. But the good news here is we're at an inflection point, because for our industry, as it moves towards consumer-driven, because individuals, Marcia, when they move into the exchanges or if they stay with their employer, they're going to make more of the healthcare buying decision, spending decision, and saving decision. Our opportunity as an industry, and we owe it to the participants to do this, is to integrate health and wealth saving and spending. That is the huge opportunity that's ahead of us today.
And I want to jump in for a minute, and then I'm going to get to Rebecca. I mean, I want to give props to, I think Eileen's out here somewhere, but Eileen Ferenzi, who's, a ERISA attorney, she said, along the lines of Doug, there are only 4 things that people really care about in life. Their house, they want to be able to afford a house, they want to educate their kids, they need health care, and they need retirement, right? So there's 4 things that we've always been able to do. Housing prices has gone up and down, but education, likewise, has gone up 5 times at the rate of inflation. Health care is 4 times as much. So the squeeze is at that level, right, at healthcare and education. And at some point, people are going to say, I just can't afford to do all 4 of these things, and I'm going to have to pick and choose. And that's I think, Doug, why your point is so well taken. Rebecca?
So from a compliance perspective, I think the other issue with the Affordable Care Act, Marcia touched on this when she mentioned the issues related to HR budgets. You know, the ACA is one of the most complex pieces of legislation that has ever been promulgated. And for the average plan sponsor to really be able to figure out which components of it apply to them and in what circumstances is going to take a tremendous amount of effort. And, you know, I think plan sponsors are particularly overwhelmed right now, just trying to figure that out. What the end result and the end impact will be on those employers, I think remains to be seen, but just that administrative burden is going to really cause employers to feel really trapped and frozen in terms of really focusing on, you know, contributions to a retirement plan or plan design changes that may be appropriate in the future.
Can I throw in another question for you all in the small business world? Because we're seeing this here in Louisiana. We have a lot of small businesses. They're taking, a lot of these small businesses are just throwing everybody into the exchanges, right? And I think it goes to your affordability question. But if you throw them into the exchanges and it is affordable, does that actually free up dollars, right? Suddenly they're not having to provide health insurance, and now you've got folks who would have more dollars available for deferrals, right? Maybe? No?
And no, it really depends on if there's going to be a premium tax credit or not. And for many people, there will be a premium tax credit, and there will likely be a fee. As effectively right now, it's $3,000. My understanding is that is going to likely ratchet up within the next few years. So no, quite the contrary. I think people think an easy and quick solution is going to be to dump people on the exchanges. When those exchanges implode because of lack of viability, it's going to come back on the employer as the funding mechanism, without doubt.
Fred?
Let me try a very different angle on this, because they've already said all the smart things there are to say about that. I read an article recently that said our kids, people in their 20s and 30s, switch employers every 4 years or so. So while they work, they're going to have, I don't know, multiply that out. That's, you know, 10, 15 different employers in their working career, 20 maybe, and which means they're not going to be in the same 401k plan all along, which creates some issues in its own right. How are you going to help them consolidate all that money? Will it be in IRAs? Will providers get better at pulling the money from the old provider's plan to the new provider's plan? What's going to happen? But tying this back into the Affordable Care Act, that same article went on to say that now that people can buy at reasonable prices health insurance off of exchanges, that is going to free them up anymore, because they will no longer be held captive to an employer's medical policy. That it's going to be even easier to move. That taking a whole different aspect of this that people haven't talked about much anyway, saying that affordable health care will buy economic freedom. So I think it's entirely possible that if we get past the next 5 years in terms of all the burdens that we have to deal with this new law, and I know we've got, I don't know how many attorneys we've got in my firm, 10, 15 that are working almost around the clock on the Affordable Health Care Act stuff. But we get past all that, and then what is the future beyond that? And one aspect of it that I think will impact us is there's going to be freedom of movement, that the value of a worker is going to be their human knowledge, their experience that they can carry with them from employer to employer. And technology, for example, will facilitate that, because who doesn't use Microsoft Outlook, no matter what employer you're working for? So I think we're becoming a freer, more open, more competitive, more dynamic world. And I don't know what the long-term impact of that is on 401ks. One other quick thought, to throw out a real contrarian view, and maybe some of y'all will get upset with me, but I will bet you money that as much as today we feel the sluggishness of the economy, that the Federal Reserve is right, that we're developing momentum as an economy, we're not too far away from breakout speed as an economy, and that 5 to 6 years from now we'll be talking about inflationary wage prices, wage pressures, that the middle class is making a lot more money, because we will be beyond what the internet and globalization has done to America's middle class, which is to make the value of their labor less so. We're now educating in colleges in America today the highest percentage of young people towards college degrees that we've ever had. So to pick up on Doug's theme of a flexion point, I think we're at a serious long-term flexion point about individuality, freedom, movement, and how are you guys going to deal with that? I mean, I don't know. I don't know the outcome on that, but it's going to impact everybody in this room if my vision is even halfway right.
Well, and I'm seeing, I work with a lot of young people who are in college, and their biggest concern about your business, about advisors, is they need to see the need for it. They're looking at technology and online advice and all that, and we'll talk about that throughout the conference, but they're saying, tell me, Sarah, why I need an advisor. I mean, and that's a big issue.
I agree with that. I mean, I think you can deliver an asset allocation model and select mutual funds to populate it over the internet a heck of a lot cheaper than any of you guys can do. My kids have grown up with it. My son's at the Berklee College of Music. I don't know if you all know what technology has done to music, but it's changed the game. And these kids grew up with iPods and, with the whole thing. They think that way. They'll be able to adapt to that change in our area as well. Right. And so I think, that my view is that your value in that world is consulting. Apropos of what Sarah said earlier, calling TPAs consultants. That's the high value proposition. Asset allocation and investments are going to diminish in value. That they're going to be priced, they're going to be disintermediated by the internet.
Which is a great segue into Doug, who is kind of our policy guy. He's coming from the Hill and also now in private industry. So Doug really wants to make a kind of a paradigm shift here in our normal conversation, away from fiduciary and regulatory rules and more towards what the future holds. So Doug, I'm going to turn it over to you.
Great, thank you. So I'm a recovering ERISA lawyer, unlike all of you, so I can go into the policy realm quite adroitly.
Yeah, when she said I was a policy lawyer, it's like, I know, I'm drafting stuff.
Yeah.
I'm a practicing ERISA lawyer.
Right.
So I'm going to offer a different perspective as I land the plane today. I think the economic and political survival of our retirement system that we work in today, all of us, really depends on driving greater levels of financial wellness or better outcomes from the system. I mean, at Fidelity, our retirement savings assessment, which looks deeply into 2,000 families' financial affairs, came up with a pretty grim report that said the median American household is on track, and we've all heard these statistics, to achieve about 71% of their essential expenses. The group that's most at risk, Fred, is the Generation Y, the me generation, as we project their retirement security. And I think our regulatory system did a lot of good in the past. ERISA's 40 years old this year, and it was designed for a different time and for solving a different problem. And I think we need to modernize ERISA. I mean, we've talked about a lot of things, 3 different fiduciary standards, all this compliance, 3, 16, 18, 23 hike. I think that was one of Peyton Manning's plays, by the way.
How well did that work?
Omaha hike. And so, I think the system that really regulates and thwarts design on a fiduciary footfall or fear basis is not what we need to take the system going forward. I think we need to modernize ERISA to allow, and this is where your value proposition is, as advisors, as record keepers, and as lawyers, which is to look at the retirement plans and the health savings plans, and I would say eventually the other benefits, and design an entirely new safe harbor. One that's built on your most important value, which is to help your participants and the plan sponsor drive higher levels of financial readiness. And I think that's an approach we need to take to our clients, we need to take to Washington, and something we need to think about in earnest. I mean, at Fidelity, we've launched an initiative called Better Outcomes, where we've taken our vast database, and we've figured out there are about 118 data points on every individual in our system. We have 300 million points of decision.
Look at like NASA, you're like the NSA.
Just about. To start help individuals and their advisors predict behavior on how to put people on an individual path towards financial readiness. As long as, and Fred, to your point, as long as we have them in our workforce. Instead of saying, for example, my savings rate is 6% because it's a safe harbor, or 3%, that's meaningless to me. But if you tell me my health savings, my retirement savings, my non-qual, my defined benefit plan, if I'm lucky enough to have one, puts me on a projected path based on my age, my income, my morbidity, my projected mortality, puts me on a path to an income replacement rate of, not a promise, a path to 85%. That's what we want to go to policymakers. That's what I challenge all of you to step outside what you think about. Join us. And we're looking for people that want to think ahead this way and really modernizing and creating a new system. I think it's absolutely critical for us to do that as we look forward. I mean, you think about the future and what it looks like. Sarah, and I'll end right here. Think about where we are now. We're at static savings rates. We need to do income replacement at life stage. We're at independent benefit decision, independent health decisions, so Marcia goes to your point. Independent health decisions, independent disability decisions. We need to go to integrated product buying decisions, emotional, cognitive, connected. We talk about annual benefit statements and financial literacy. I suggest to you, we can't financially educate everybody in America in the right place. They don't want financial literacy. I don't want financial literacy. I want the next best step. That's the financial education of the future, and that's your strength. I'll end there.
Fantastic. And we do have another 15 minutes if you guys want to ask questions. But Marcia, I know you want to get in on this. I'm sure I can feel it.
Yeah, I actually do. I've dedicated the past almost 29 years of my life to the statute known as, getting old, to the Employee Retirement Income Security Act of 1974. And listening to Doug talk, I was struck actually by his brilliance, but also by the fact
Can you tell my employer?
Also by the fact that I'm concerned that, yes, that I'm concerned that we not throw babies out with bathwater. Look at what we have accomplished. We've got TPAs, we got record keepers, we have financial advisors, we have ERISA lawyers, we have consulting actuaries, et cetera. And we have a system, I think, in need of tweaking, particularly with respect to the middle class, obviously. But you know what? It isn't that broken. And there's some easy fixes. I'm going to throw out 3 right now. I think if all 3 are done in conjunction with each other, a lot of this crisis will be at least somewhat ameliorated. Nothing is perfect, but be careful, as Fred said, was what we wish for, because significant titanic change can also wreak a havoc on a system that is already under stress. So let me tell you practically what my 3 points are. Some of the non-discrimination rules are antithetical to small business having pension plans. The one that I know you'll all agree with me on are the 416 top-heavy rules. They need to be changed, preferably eliminated. They're traps for the unwary. 2, Legg Mason Advisory Group came up with the concept of the stretch match. I'd like to discuss it in 2 different contexts. I was honored to be part of this because I think it's part of the solution. Currently, if you have a 401k safe harbor plan, then you don't have to do basic non-discrimination testing if, in general, you match 100% of the first 3%, 50% of the next 2%, so you get 4% on 5% of elective deferrals. What if you elongated that so you get a 40% match on $1 up to 10%? Bingo. You have, through the power of inertia, a 14% effective contribution rate. Concomitantly, there's the auto-enroll, auto-escalate safe harbor, whereby the employee has to contribute 100% of the first 1%, then 50% of the next 5%, for a total of 3.5% and 5% of elective deferrals. Why not stretch match that out at 35% to 10%? That's 13.5. 0.5% savings. You couple that with a nudging effect of QDIA, and you go a very, very long way in forestalling, ameliorating, limiting, truncating this crisis whereby we change probably 20% of our economy for a problem that can be fixed with solutions that are already being discussed and debated currently.
And so one of the things I'd like to bring up, and Brian taught me this, and I think it's one of the greatest pieces of advice anybody's ever given me about government. He said, incremental change is good. Incremental change
That's
is the
what I'm
best thing.
saying.
I mean, look at the Affordable Care Act. Whether you like it or not, it's not incremental change, so it's a burdensome thing. So I love these ideas of incremental change. I would add to your auto enrollment, as somebody who deals in this business, and I'm sure record keepers and TPAs would agree with me, let's get rid of the onerous penalty for screwing it up. Right? So if you mess up auto enrollment as an employer, you're on the hook for making those deferrals for those people you missed. Unless I am, him from above, I'm going to make that mistake. I'm not going to be able to get all those people in. And I said that I've seen mid-sized employers pull out auto enrollment because they're so frustrated with that fix, right? With that EPCRS fix. So that's another kind of incremental change. Fred?
I want to make a point, so you all play along with me for a minute here. Forget everything you know about the history of 401k plans, and let's assume we're inventing a deferral retirement plan today. And I think the conversation will go something like this. Companies aren't going to sponsor defined benefit plans anymore, so we really need to get employees to save, on their own for retirement, because we don't want a society of 80 and 90-year-olds living in cardboard boxes on sidewalks. So let's set up a deferral-based plan. I think it'll work the best if they do it through their employer and it gets withheld automatically and sent off to the investments. And so we'll set that up. We'll have good investments. We'll have fiduciary responsibility. We'll have reasonable expenses. We'll have this great package that will give the employees, but we've got to put at least one cruel joke in there somewhere, because we can't have it all be good. What do you say we don't tell them how much they need to save to retire? Does that describe the system we have today? Sure.
It does.
That's it. That's
Yeah.
today.
I mean, Fred, what you just described is the Back to the Future plan. Before we had 401k, which was a very clever thing by our industry to get employers out of the investment business, give it to employees, we created this fiction that some of it's your money, some of it's employers' money, we'll get you to save with this match. The way it used to work was the old money purchase pension plan. The employer said, you make $110,000, I'm going to take $10,000 a year, I'm going to put it in the plan, I'm going to hire an investment manager to take care of it, you get a diversification right at age 55. That was the intermediate step that we lost somewhere.
And I think
I don't know if we can put the genie back in the bottle.
Yeah, my ultimate point is we're getting back to that. I am a great fan, and I think you should be too, of the DOL proposed regulation we're going to get later this year that I believe will mandate retirement income projections on the quarterly statements of 5,500 of participants, quarterly benefit statements, and participant-directed deferral-based retirement plans. Because the minute the government mandates that, then the private sector will take over. And what will the private sector do? Your guess is as good as mine, but I've thought about it. I think what the private sector will do, well, the first thing they'll say is, well, gee, the participant's going to ask if that's how much I'm going to get. How much do I need? And so then the benchmarks will come up, like Doug used 85%. 80% may be the most common one that people use. There's a Aon Georgia State study from a few years ago that a lot of people cite for that. Some folks I've seen as low as 70% income replacement ratios, Social Security and 401k account combined. But then all of a sudden the participant's going to get that number and they're going to see, well, I'm on target for 60%. You said I need 80%. What do I do? How do I close the gap? That's gap analysis. You guys are going to be doing gap analysis. Right. Coming out of your ears, you're going to be running seminars for employees 50 and over. You're going to have all the software there. You're going to be doing all that stuff. That is a big deal in your future, and helping them then have sustainable lifetime income in retirement will be the next step after that. As a part of that, though, the providers and the advisors are going to say, wait a second, there may be other assets out there. There may be personal savings, there may be other IRAs, there may even be other plans. How do we consolidate that? So I think that DOL regulation, when it becomes final, maybe a year from now, maybe a year and a half from now, will lead to all those other things I said, ultimately with the consolidation of assets. Because, and frankly, I think advisors, for the most part, are in a pretty good position in terms of being the ones to consolidate the assets. Because what I think people want, and I hope this just isn't because I'm old, is I think, notwithstanding what I said earlier about the internet and disintermediation, I believe that people want to talk to someone. I think they want to trust someone. I think they want to say, what do I do personally? And the minute you get to that, I think that favors IRAs, and I think that favors consolidation. I think it favors holistic financial planning and investment planning.
Question.
So great segue, because that goes into my question, which is earlier today, Preston Rutledge was here with Brian Graff, and they kept talking about the proposed cap. So
Are you talking the 3 million cap?
Yes.
Okay.
And so what I think is interesting about that, of course, is that Social Security is imploding, and we want people to save more, as well as it's not as though the government's not going to get their taxes. If they put it on the Roth side, they're going to get the taxes today. If they're going to put it in the pre-tax deferral, they're going to get the taxes later after 70 and a half. So if Social Security is getting ready to go away, why would they cap it? Your thoughts?
I think a lot of it is just political.
Yeah.
Very few people ever get to present value defined benefits in conjunction and combination with 401k, a 403b, a 407b balances of 3 million. But if you have that 3 million demarcation line, I know it's somehow related to the J and S of DB, but it really isn't. It's like these are wealthy people, and they don't deserve the benefits of tax deferral anymore. It's taken on the, like 5 standard deviations of the statistical norm. It's almost an irrelevancy, but it makes good political hay to be against these people, that it's unfair that the tax system benefit them so much. Having stated that, however, when I first started practicing law, there was a limit that you couldn't take up more than, I think it was 155K from a plan. So everything old is new again. These limits that we think are set in stone, the 402G limit of 17.5, the 404 limit of 25% of compensation being deductible, the 401A17 limit of 245K right now. All these things are man-made. They ebb and they flow, they rise and they fall on societal need and what we can afford as a pension, as a country for our pension system. And we are, and this seems to be the word of the day, at a veritable inflection point as a society. What can we afford with our pension system, and what do we want from our pension system?
Well, and I think
those two issues are in fact separate and distinct.
Right, and so I think that it's a political question. And Brian, one of the things, I mean, to give a big plug for NAPA, which obviously I've been involved in for a long time, there is nobody who is the voice of that like this group. Nobody on the Hill is making that argument except you guys and Brian and the NAPA folks. I mean, it is so critical that they hear this message from us. I've been on the Hill. They look at me and say, well, Sarah, these are rich people. I don't care about rich people. And that's really what they're telling you. So it is a political thing. But I would also argue Social Security is fixable. You know, we can raise the retirement age, we can means test it, which they're going to have to do. Medicare is going to be the bigger issue. Yep. Social Security is not going to go away. Medicare is going to cost us the big dollars. So I think, but it's a political thing. When you're talking about political things, as Marcia's saying, it's all arbitrary. The best thing we can do as a group is get involved, and our political action committee, obviously, another plug, but those are all very important ways that we can make changes.
If I could have just one more quick comment, I'm sorry. If it's political, understand it's a slippery slope. That's why people have red lines. If it's okay to beat up people with 3 million, limitations can change. Then maybe it's okay to beat up husband and wife with 3 million.
Right.
Then maybe it's okay to beat up at 2 million, then 1 million. Right. Do you see what I'm saying? These lines in the sand matter philosophically, because once they're breached or broached, regardless of where you are, understand they can change, up or down, depending on certain winds
Fred, you got 10 seconds.
Yeah, I think that proposal, the cap, the so-called $3 million cap, is dead on arrival. I just don't think it's administrable. But the concept is that you know, the guy who makes $500,000 or $1 million a year doesn't need tax incentives to save, either as a practical matter or as an incentive. But the people further down the line may be incentivized. On the other hand, you have to balance that, particularly for professional firms and small businesses, that if you don't have enough of incentive for the key guys, they're not going to put in a plan, or they may not put in a plan. So it's, somebody once described, a judge described taxation as the plucking of the feathers of a goose with the least amount of hissing. It's that balancing act. Where do you balance those who don't need it with still getting them to put in the plans? And I think viewed societally, that's the issue.
I want to thank every one of you. What a great session today. And I want to thank all of you, and we'll see you at the networking reception.